Okay, so when I say lawsuit, what pops into your head? Probably a dramatic courtroom, right? Witnesses on the stand, lawyers shouting, objection, the whole deal. But here's the thing, a huge number of legal battles aren't fought like that at all. They're fought entirely on paper. So today we're diving into this world of silent written warfare to demystify what's known as the application procedure. So, yeah, on the one hand, you've got the Hollywood version we all know and love. But on the other side is the reality for a ton of cases. A dispute that's decided completely on the strength of documents. The entire story, every piece of evidence, it all unfolds through sworn, written statements. It's a game of precision and preparation, not some big, flashy courtroom performance. So, to make sense of it all, here's our game plan. We'll start with the basics of a lawsuit on paper, then look at the core documents that built the case. We'll explore the different types of applications, the procedural playbook, and some of the most powerful orders a court can grant before we land on the final verdict. All right, let's jump right in. Section 1, a lawsuit on paper. Let's get to grips with the core idea behind these cases, which are also known as motion proceedings, and find out why they're actually so common. So, what exactly are we talking about here? Well, the application procedure is a legal process where a court decides a dispute based entirely on written evidence. Instead of putting witnesses in a box, the parties testify on paper, using these really important sworn statements called affidavits. The person who kicks it all off is the applicant, and the person they're up against is the respondent. It's their written stories that the judge has to weigh. Okay, so how do you actually build one of these paper lawsuits? That brings us right to Section 2, the core documents. And you should really think of these as the literal building blocks that form the entire foundation of the case. The process is basically a very structured, written conversation. First, the applicant gets the ball rolling. They file a notice of motion, which is just a fancy way of saying, here's the court order I want, and a founding affidavit. This document is huge. It contains their entire story and all their evidence. Then the respondent gets their turn with an answering affidavit, where they get to challenge the applicant's facts. And finally, the applicant gets one last word with a replying affidavit, but only to deal with new points the respondent brought up. And this is a super critical point. This quote from the famous Titties Bar vs. ABC Garage case makes it crystal clear. The applicant has to put all their cards on the table from the very beginning. You can't hold anything back or try to add a new argument later on. The entire case has to stand or fall on the strength of that first document alone. And just to be clear, an affidavit isn't just some casual letter. It's a formal, written statement of facts that's confirmed under oath. That means the person making the statement is legally swearing that it's all true. Then it's signed in front of an official, a commissioner of oaths, which gives it the exact same legal weight as testimony in a courtroom. Okay, Section 3. Now, not all paper lawsuits are built the same. Let's look at the three main types of applications. You can think of them as different blueprints you'd use for different situations. This table breaks it down perfectly. First, you have an ex parte application. That's Latin from one party, and it's when you go to court without even telling the other side. As you can imagine, it's pretty rare and only for extremely urgent matters. The most common type is the bilateral application, which is your standard two-party dispute. And finally, you have interlocutory applications, which are like smaller procedural requests you make inside of a bigger ongoing case. On to Section 4, the procedural playbook. Now we're getting into the nuts and bolts of how these cases move forward, and the single biggest problem that can completely derail the entire process. This really is the million-dollar question. This whole system works beautifully when the facts are mostly agreed on, and the real fight is about how to interpret the law. But what happens when the applicant's sworn statement says one thing, and the respondent's sworn statement says the complete opposite? Well, that's called a dispute of fact, and it's the application procedure's kryptonite. As the court warned in the Room Hierco case, if you see a serious factual dispute coming from a mile away, you probably shouldn't be using this procedure at all. Because, how can a judge possibly decide who's telling the truth just by reading two conflicting documents? But there is a clever way around this called the Plascon-Evans rule. Here's how it works. Generally, the court will accept the respondent's version of the story. But, and it's a big but, if the respondent's story is just so far-fetched, so unbelievable that it can be rejected just by reading it on paper, the judge can ignore it.
It's a really high bar, but it stops people from derailing a case with completely ridiculous denials.
And just to give you a sense of the pace, here are the standard timelines in the High Court. Once the case gets started, the respondent usually has 10 business days to say they're going to fight it. Then they get another 15 days to file their answering affidavit. After that, the applicant has a final 10 days to reply. It's all very methodical, and it keeps things moving.
Now for the exciting part. Section 5. Urgent and special orders. Seriously, these are the legal power moves, the tools that let parties get incredibly fast and sometimes pretty drastic results from the court.
First up, urgent applications. This is how you jump the legal queue. If you can prove to a judge that waiting your turn is going to cause you serious harm, the court can just throw the normal rulebook out the window and hear you immediately. But as the Luna Mooble case shows, you have to prove genuine urgency. If you can't, the court will just strike your case from the roll for crying wolf. A common goal here is to get an interdict. That's a court order telling someone to stop doing something. An interim interdict is like a temporary fix, a Band-Aid. It just freezes the situation to prevent more harm while the main case gets sorted out. A final interdict, on the other hand, is permanent. To get one of those, you have to prove you have a clear, established right that's being violated. And that brings us to one of the most dramatic and invasive orders in all of civil law, the Anton Pillar Order. This is basically a civil search and seizure warrant, and it's one of the most drastic orders in law. It's granted ex parte, remember that means without the other person knowing, and it allows the applicant to enter the respondent's property to search for and seize vital evidence. It's only used in extreme cases where there's a very real fear that the respondent will destroy crucial proof the moment they find out they're being sued. All right, let's bring it all together in our final section. Section 6, the final verdict, where we'll summarize the key takeaways from our deep dive into the paper-based lawsuit. So here are the crucial points to remember. First, this whole procedure is incredibly fast and efficient, but only when there aren't major fights over the facts. Second, that founding affidavit is the whole game. Your case has to be perfect from the start. Third, the biggest hurdle is a genuine dispute of fact, which can stop the whole process dead in its tracks. And finally, special tools like urgent applications and interdicts can provide powerful, swift remedies when you need them most. And that leaves us with a final question to think about. The application procedure offers incredible speed and efficiency by relying on paper. But a traditional trial gives you the chance to see a witness, to cross-examine them, to search for the truth in person. So what's the right balance for delivering true justice? It's the central tension at the very heart of this entire legal process.